record in matter 430 CV 2021-00029, Kathleen A. Dudley versus Jody Armijo. Will parties please state your entry of appearance?
Yes, I'm Kathleen Dudley, the petitioner.
Jesus Lopez, Your Honor, on behalf of Jody Armijo, who is also present today.
Thank you for your time and attention and your patience. We were running late this morning on a matter that went beyond its time, so thank you for your patience. The matter scheduled on today's docket is a motion on behalf of the plaintiff, motion to stay proceedings. Ms. Dudley, are you ready to proceed?
Well, with all due respect, I have a few matters I want to clarify before we begin this hearing. You have taken the oath of office to support and uphold the Constitution of the United States of America, of this state, is that correct? Pursuant to your oaths, you are required to abide by these oaths in the performance of your official duties, especially those before this honorable court. Is that correct? Ma'am, by being quiet, and by not making...
We're here for a motion.
By not...
We've been through this before. Are you going to recite the same statement? Is that on the record? You can make your statement. This is your opportunity to present the motion before the court. So we have a certain amount of time. If you'll please move into your motion.
Yes, ma'am.
Court to stay.
With all due respect, you're required to uphold the due process of law. However, by your lack of answering, it appears that you have either taken the oath and have no intention of abiding by it, and I know you have taken the oath because I have an IPRA copy of it and have submitted it to the court, or you have, and this is required by the Constitution in order for you to discharge your official duties as a judge. In either event, your answer demonstrates that you will not uphold due process of law and protect my constitutionally secured rights, which are guaranteed to me during these proceedings. Therefore, ma'am, you are disqualified and you must step down. Now, as a public servant, you have perjured your oath and you've invoked the self-executing sections of 3 and 4 of the 14th Amendment, vacating your office and forfeiting all your salary and your pension. You are truly and fully disqualified. Now, I appear here before this honorable court by special appearance as a living, breathing, natural-born woman on the land, an American citizen, with and claiming all my inherent and guaranteed rights in the federal and state constitution, and with my name properly spelled in upper and lowercase letters. Are there any objections to what I just stated? I will now proceed further. I have the constitutional right to present my case without interruption from the court or opposing counsel. Any opposition to my right is a violation of due process of law. I have the right to present my motion to stay pending appeal. I have the right to rebut the unlawful claims by respondent by and through counsel in his response to my motions to stay that he submitted to be part of this hearing today. As I filed and spoken to the court, in all my filings, hearings, and trials, and ma'am, I would appreciate your attention, I am speaking on my behalf, sui juris. Yet counsel continually trespasses against my First Amendment rights with an audacity that is shocking to the goodwill of law-abiding citizens. It is an ongoing violation of my constitutional rights, due process of law, and puts fraud upon the court. By the court, ma'am, upholding this fraud, it is a violation of due process of law. And U.S. versus Throckmorton, fraud vitiates everything. All actions, all alleged authority and jurisdiction conducted in, under, and through fraud are nullities. In order, ma'am, for your rulings to be valid, your rulings must be constitutionally supported. Therefore, your rulings are null and void. No court rules can abrogate my constitutionally guaranteed rights, and that is the Supreme Court ruling, to wit, Where rights secured in the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. That's Miranda versus Arizona, 1996. And in court rules and statutes cannot supersede my constitutional rights. And this is NMSA 1978. The Supreme Court of New Mexico states that such rules shall not abridge, enlarge, or modify the substantive rights of any litigant. Now, the court has converted my constitutionally secured rights into a crime. My rights to protect myself against harassment on my own property, to protect my family, to protect my friends, to protect my animals and my property. The United States federal court ruling, to wit, the claim and exercise of a constitutional right cannot be converted into a crime. Miller versus U.S.
Ms. Dudley, you came before the court today on a motion to stay. We have a limited time. Will you please address your motion to stay?
Yes, I will be there in a second. The court has continually denied and consistently my constitutional rights and due process of law through unlawful orders and failure of notification and unlawful rulings. The court has refused to rule on my motions, to bring any of my requests for motion hearings forward, and on the demand for findings of fact and conclusion of law based in the authority of the national Constitution, in particular Article 6, Clauses 2 and 3, regarding the unconstitutional rulings issued by Marie Sanchez-Gagne acting as judge, which I filed June 6, 2022. Ma'am, you did not respond to this demand. You gave no constitutional facts, the constitutional authority for your rulings. Therefore, your rulings are invalid because they are not constitutionally supported. And you are mandated through your sworn oath and also by the mission statement of the New Mexico courts. The national Constitution is the supreme law of the land, to which you swore your oath to uphold. Article 6, Clauses 2 and 3. Your bias, disrespect for me, the disrespect for my constitutionally secured rights, and the denial of all my truthful filings, exhibits, and evidence are egregious. You've been ignoring one of the parties in this case, myself. You have set aside my constitutional rights. This court is a complete fraud, while supporting all the rumor, opinion, hearsay by opposing counsel and his alleged witnesses. The violation of equal treatment before the court and due process of law stands out. Ma'am, this court is a failure, which is the reason I am appealing to the Court of Appeals, because this court has denied my constitutional rights. Now, there are 4 factors that must be met in order for a motion to stay to be granted. And the first is one to confirm that this appeal will succeed. And it will. Because in my filings, I show clearly that I have been denied and violated my substantive rights. This court has kept my court exhibits from being filed, only filed the day after the trial, with the facts and evidence, along with my filings from being entered into the record proper. My request for all my motion hearings were ignored and denied, which is a violation of due process of law. The 2 orders subsequently that you put in place were again a violation of my constitutionally secured rights to bring my case forward, secured under the 1st and the 6th and the 9th Amendments, to redress government, to stand before my accusers. This is an egregious violation of due process of law. You denied my right to petition for a civil restraining order for the court for trial, while respondent was given a trial 3/4 of the time to present his false, malicious counterclaim against me, an egregious violation of due process of law. the flagrant violations of my constitutionally secured rights and due process of law went through this entire shambles of a kangaroo case in this court. The second aspect that was that I will suffer irreparable harm if the stay is not granted. And yes, I will be harmed financially, mentally, and emotionally. Today, there is ongoing harassment against me. My life has been threatened, and I have no court to appeal to at this point because there is no court action that is taken. Respondent with his alleged witnesses continue to harass me. This is a violation of my Fourth and Fifth Amendment rights to be safe and secure on my own property. And yet, the court has paid no heed to any of my valid concerns. I have filed an unrebutted affidavit to the court, which has gone completely unnoticed and refused to be entered into the record proper, considered extrinsic evidence by both the court and by opposing counsel. My witnesses were given no weight, and yet the alleged witnesses by the felon, twice convicted, the first time for first, second, third degree rape against a woman and put in prison, and the second, aggravated assault against a household member with a lethal weapon who served 3 years in New Mexico. A total of 14 years in prison and jail, which I have information on, which I filed with the court from Grand County, Colorado, confirming all of this. And everything that was presented in the trial by these alleged witnesses was allowed by the court and encouraged by counsel on hearsay and opinion, shameful actually, unconfirmed rumors, no one presenting any evidence to show that I had done anything that I was charged, that they said I was doing. Nothing, not one bit of evidence. And yet you, ma'am, took their word over mine. But not one bit of evidence. And even when under testimony, under cross-examination, respondent agreed to every single TRO violation, every single one, and also denied the tape recording of the audio and the video by the sheriff deputy, stating the contrary to what he had recorded of his violations of damage of my property and theft of my property. This collusive conspiracy is almost laughable, to twist and distort and turn this from a 33-year criminal lifespan of respondent and attempt to turn me into the criminal who has absolutely no criminal background nor criminal incentive or actions, and certainly no evidence that has been presented by counsel, opposing counsel. So it had to be hearsay and opinion because he had no evidence, not one bit. Again, the claim and exercise of a constitutional right can't be converted into a crime. But that's exactly what a respondent buying through counsel and this court is intending to do. Now, the lower court has ignored my constitutionally secured rights and appears to be punishing me for expressing them, as is my right and duty, ma'am. Now, I did not hire Jesus Lopez. Therefore, I have no financial obligation. I have no contract with him to pay for Mr. Lopez. And Article 1, Section 10 of the national Constitution does not permit government to impair the obligation of contracts, nor to impose the obligation, since the court is mandated to uphold the Constitution, not violate it. And also, if you'll notice, I don't know if you are aware of this, but the Court of Appeals uses the Constitution to support their own rulings. Now, it's unconstitutional for the court to attempt to impose obligations of contractual payment upon me and permit Respondent Armijo to engage in unjust enrichment. It's called extortion, by avoiding his responsibility and obligation to his attorney by carrying out a fraudulent, spurious counterclaim against an innocent woman who has harmed no one. And the court has not, in any case with the alleged witnesses, asked for any evidence to support any of their opinions or any of their hearsay. All she did was listen to them. Ma'am, that is not a lawful court of justice and constitutional foundation. The third claim is that I would not suffer undue harm and prejudice if the stay is granted. Now, the other party would. Now, respondent has been able to afford hiring this attorney for the past 2 years. Obviously, he has substantial funds to be able to do this, and he has recently upgraded his vehicle. So I would say that he is in a position right now to afford such a lifestyle, and it is unjust that any of these charges or any of this is brought against me. On the fourth one, which is the public interest weighs in favor of the stay. Now, I was subjected to malicious prosecution on ridiculous claims of grounds that are non-existent and defy logic and common sense. Now, this court, and ma'am, you, pursuant to the mission statement of the New Mexico courts, must uphold and protect the constitutionally secured inherent rights guaranteed to the people, and in this instant case, to me. So there is tremendous public interest factor in this, because if it is not upheld, then the entire public is denied their constitutionally secured rights. And the mission statement is a mandate for all judges in the Court of New Mexico. Furthermore, my constitutionally secured rights, again, have been totally denied and ignored and violated. And that would go for all of the public if you were to make this case one where you did not uphold my rights. Now, the violation of due process, the denials and violation of my inherent constitutionally secured rights and unequal treatment under the law are the reasons for requiring and demanding respectfully this motion to stay. Now, I wanted to talk about the elements having to do with the response to my motion to stay. And first off, I want to state that there were 9 alleged witnesses, not 12. It gave the impression in how respondent, by and through counsel, wrote his response. And this was a misrepresentation, putting fraud upon the court. Now, the alleged witnesses offered only opinion, and the court unanimously took the alleged witnesses' word over mine, appearing biased in all these rulings. Now, the fact that there's a claim that my presence causes fear and apprehension among the people of Los Hueros, there's no evidence of that. It's just an opinion, a statement. And only of friends of respondent and of William Groffman, who was charged and convicted of harassment against my husband, Dr. Don Hamilton, and myself twice. Now, the historical width of the road is 12 feet from my gate all the way through up to the Groffman property. Cindy Pickard has a second easement width starting at the Willows that is 20 feet wide. Now, ma'am, you have no lawful right to extend the width of my historically set 12-foot road. Furthermore, it was not argued in this case over the past 2 years, nor should you have any reason other than bias to impose this upon me. This is a crossover from the Alcón case. This was never brought up in any of the hearings, none of the trials. It was not brought up in any of the pleadings. It was not an issue in this case until your final judgment. The road width itself, you have no lawful authority to rule on this. Crossing over cases is a violation of due process of law and again forfeits jurisdiction. There is no substantive evidence, says opposing counsel, or that he said he has a substantive evidence in his case. Yet it was all opinion and all hearsay and all rumor, with every single alleged witness who had an axe to grind against me. Because as the police officers once said when they were coming out here and taking the complaints that I had, that these bullies could not stand a woman who was independent enough and courageous enough to stand up against these bullies. And they recommended that I get a gun and use it. Now, that's not my way, but it was what law enforcement stated. Now, it's absolutely false. I did not attempt to deny Garcia access through my property to the acequia. The day before the trial, November 14th, 2022, he drove his four-wheeler onto my property and sat at my inner gate. I did not come up to him in a belligerent and threatening manner. He was carrying a gun. He was not fearful of me.
Ms. Dudley, we are running out of time. You've been speaking for almost 30 minutes, 25 minutes, and this was scheduled for 30 minutes. We did start late, but I allowed you additional time. So I would, if you could wrap this up, and we're going to allow the Ms. defendant to respond.
Okay, I just a few more minutes.
Okay, 2 minutes. I'm clear the clock right now.
The court has no right to take someone else's opinion over mine when they have absolutely nothing to substantiate it with, and the court did not ask for any. You could ask for his own filming of me, and you'll see that there was nothing belligerent and there was no aggression, and I did not stop him. It was absolutely ridiculous. There was also an error about Dan Mullane. He was the one stopping me from being able to leave. He was on his own property, blocking me at my property. The court made a serious error. Regarding the documents that I filed with the court, I seriously rebut all of that. It is my lawful right to be able to speak, and if I speak with tenacity or temerity, it is only because this court has violated my constitutionally secured rights, my due process of law. And the only reason that I have presented further documents was because of those very violations. And when I presented my requests for motion hearings, then the court, on August 18th, 2022, enforced an unlawful order that I could no longer put any more motions before the court. Yet the court refused to allow any hearings for my motion hearing requests. Now, there's a statement. I'm just about done. This is about exposing the lack of justice, which opposing counsel appears to promote, and the gross twist turning away from the criminal nature of the respondent in an attempt to criminalize me, a woman without any criminal history, tendencies, but a very strong sense of right and wrong when it comes to protecting my property, my family, my friends, and my animals, as guaranteed in the Constitution, particularly Amendments 4 and 5. I intend to reply to respondents' response and intend to continue to expose the egregious violations of my constitutionally secured rights and due process of law to the Court of Appeals.
Thank you, Ms. Dudley. I'm going to now allow the defendant to respond. Go ahead, Mr. Lopez.
Your Honor, do I have any time left at all?
Yes, so you have 10 minutes left.
Okay. Your Honor, I shouldn't take that much time. I did submit a response, Your Honor. I hope that made it to the court.
All pleadings. Yes, the court has read all pleadings. Thank you, Mr. Lopez.
Thank you, Your Honor. Your Honor, first, to simplify things, this motion, of course, is controlled by Rule 62 of the Rules of Civil Procedure relating to stays. And as to the judgment awarding attorney's fees and costs, Your Honor, we made it very clear in our response that we will not oppose the motion for stay on the condition, of course, Your Honor, that Ms. Dudley tenders to the court and files with the court a supersedious bond, an appeal bond, a surety bond, as the court will direct, for the entire amount of the judgment, in this case $36,781, plus costs, interest, and damages, while the appeal is pending. And also, as provided in Rule 62, an additional amount to be set by the court for any costs, interest, and damages, which could include attorney's fees, that the Court of Appeals may later assess against Ms. Dudley. And that may likely happen, Your Honor. So in that regard, we'd suggest that the total amount be in the amount of $75,000, the appeal bond, and that it be a surety bond posted with the court and only approved by the court and only effective at such point as it is approved by the court with notice to us, of course, Your Honor. So that takes care of the stay or motion for stay as concerns the money judgment. And as the court well knows, that is a common routine practice concerning money judgments, Your Honor, so that the parties are balanced in that we don't get any money pending the appeal because Ms. Dudley might succeed. On the other hand, our interest in the judgment is secured because a surety bond is posted so that if Ms. Dudley does not succeed on appeal, the money judgment is paid. As to the judgment on the marriage, Your Honor, which the court entered on April 6, 2023, we, of course, vehemently oppose that motion, Your Honor. That, again, is controlled primarily, Your Honor, by the Tenneco case, the landmark case in New Mexico by our Court of Appeals, affirmed by the Supreme Court of New Mexico, that sets forth a four-part test for allowing motions for stay. And the first one is that the applicant must demonstrate a likelihood of success on his or her appeal. We have submitted in our response, Your Honor, all of the court's findings, which are based on direct, first-hand knowledge and testimony of each witness identified by the court in its findings, as to establish substantial evidence, Your Honor, which is also gleaned from the exhibits, including the exhibit DC2, indicating a 20-foot wide easement in the survey, Your Honor. We go on without belaboring the point, Your Honor, in our response to show that the court's findings and conclusions and judgments, Your Honor, are supported by substantial evidence. That is the standard of review, Your Honor. And for that reason, we do not believe that the court's judgment will be disturbed on appeal, because it is for this court, the trial court, to weigh the evidence. And you did that already, Your Honor. You did that during a 2-day trial. Ms. Dudley wants to relitigate the trial, and she keeps trying to try the case again, but that's been done. It was done for 2 full days, and there were 12 witnesses. That includes 3 of her own. And the court listened to all of them, Your Honor, patiently. And Ms. Dudley engaged in robust, extensive cross-examination. And the court, as only the court can do, weighed the evidence and made its decision based on direct, first-hand knowledge supported or testified to by the witnesses, Your Honor. So as to the substantial evidence test and the likelihood that Ms. Dudley will prevail on appeal, I think she fails the technical factor number 1 right off the bat, Your Honor. The second factor, which appears to be the most important, and that is the Court of Appeals in technical calls it the threshold factor, is the irreparable damage claim, Your Honor. And this one, as I pointed out in our response, is totally out the window, Your Honor. All the court's judgment and permanent injunction does is direct that Ms. Dudley be a law-abiding citizen, that she not menace or threaten or harass the people of Los Hueros. That's all you do in your judgment, Your Honor. And it's beyond me to understand how anyone can suffer irreparable harm as a result of being ordered to be a law-abiding citizen and not menace your neighbors. Aside from that, as the court knows concerning irreparable harm, if there are adequate remedies at law, Your Honor, available to Ms. Dudley to protect her interests, then she suffers no irreparable harm. In this case, of course, if anyone exceeds the easement and trespasses on her property or commits waste on her property, she has the common law trespass action available to her, as well as the other statutory action that I mentioned in our response, Your Honor. So she has adequate remedies at law, and of course she can call the cops, and she does that all day, every day of the year, Your Honor, if anything's amiss over there. So again, there's no irreparable harm by being required to abide by the law and not menace your neighbors, Your Honor. And as to the third and fourth tests, Your Honor, those also militate strongly against Ms. Dudley in this case, because the public interest here will be very, very much harmed if Ms. Dudley is allowed to proceed or persist in her harassment of the community. 2 of the witnesses who testified here, Your Honor, are public officials. One is the fire chief, a duly appointed official of the state of New Mexico. The other is the chairman of the Acequias, a political subdivision of the state. They are public officials who have been threatened by Ms. Dudley. If there is ever a threat against the public interest, it is here. These are public officials. They represent the public interest, which is water. There's nothing more important than water, and the prevention of wildfires. Talk about the public interest militating against the state. We have that here, Your Honor. And then the other public interest is the interest of the interested persons in Los Hueros who have a right to travel that road. There is a great interest that those people not live in fear, Your Honor. And if a stay was to be imposed, Ms. Dudley would be unfettered in her continued attempt to harass and menace these people, Your Honor. So as the court knows, as I said in the very beginning of our response, A stay pending appeal is an extraordinary remedy that should not be granted unless the applicant is clearly entitled to such relief. And that's the federal case, Your Honor, applying New Mexico law, of course, in Pueblo of Oaxaca versus State of New Mexico. Your Honor, I won't belabor the point anymore. Again, we agree to a stay on the money judgment, provided a surety bond is posted and approved by the court for $75,000. On the judgment on the merits, we oppose that vehemently for all the reasons stated. Thank you, Your Honor.
Thank you, Mr. Lopez. Ms. Dudley, you have 2 minutes to respond.
Yes, regarding the 2 public officials.
You're muted. Can you unmute your line?
Regarding the 2 public officials, Mr. Garcia lied and perjured his oath, and there was no request for any proof or evidence. I did not stop him from coming on to the property. I did not stop him from doing his business. That was a complete lie. I refute and rebut that with its entirety. Regarding the fire chief, as I said, my husband was the fire chief during the prior fire here, and I'm well aware of the security of the area for the people. And Mr. Molesky did not mention anything about smoke, anything about concern about fire. All he did was come through my property without requesting permission, and I have the lawful right to decide who comes onto my property, who does not have a lawful right to access my road. To disparage me, as you do, respondent by and through counsel, is an egregious act of fraud, because they are perpetrations of lies. You indicated that I call the cops. She does that all day, every day of the year. That is, again, a lie. That is fraud. You put fraud upon the court and upon me. And, Your Honor, by allowing that fraud to exist, you put fraud upon the court as well and violate my due process of law. I am a law-abiding citizen. I have done no harm. This felon is the person who I took a petition out at the advice of a law enforcement officer, and the court has failed me in its entirety through this whole case. And I sit here and have my name trashed by respondent by and through counsel. It is egregious. It is pathetic. And I must say that
Are you out of time, Ms. Dudley?
Yes, I'll finish. I'll just finish up with one more sentence. Yes, I find that that any of these rules that abrogate the national constitution as the supreme law of the land are null and void. They are a nullity. So no matter which statute.
That's more than one sentence. Okay. The court has reviewed all the pleadings, and I do want to ask you, Ms. Dudley, do you understand that Mr. Lopez is going to stipulate to the judgment and costs on attorney's fees if you place a supersedious bond? Are you willing to do that? And that would be placing that with the court while the appeal is pending.
I do not agree to any extortion, and that is against my constitutionally secured rights, as I wrote. So no, I do not.
Okay, then that was an offer that was extended by...
It was not an offer, it was an extortion.
All right, I'm going to speak now, Ms. Dudley. Please don't interrupt as I speak. The court has reviewed all the pleadings, and after our argument, Mr. Lopez did extend the supersedious bond in place pending the appeal, which would place the monies with the court while the appeal is pending. That's not money used, and that is customarily done in these cases. However, by the record, Ms. Dudley has refused that offer, so the court is going to proceed in looking at the technical factors and find that all the factors weigh on behalf of the respondent defendant, Jody Armijo. The court finds that there is substantial evidence on the record and that there are adequate remedies at law which are available, Ms. Dudley. You can always file new claims with the court, criminal law trespass there in the 4th District. You have other adequate remedies available to you if they're trespassing on your property. The court finds that it is in the public's interest that this matter remain and go forward, that the persons are allowed to access the road, particularly for the needs as stated. So the court is denying the motion to stay. And I would ask you, Mr. Lopez, to please draft that proposed order and submit that.
Your Honor?
Yes.
Just for clarification, I think this is what the court said. The denial applies to both the money judgment and the judgment on the merits. Is that correct?
That is correct. It does apply. I wanted to just articulate that the offer was made and that was denied. So therefore, the court is willing that the stay applies to both.
Thank you, Your Honor.
Okay. All right. Thank you for your time and attention. This matter is now adjourned. Thank you. Have a good day.